In July 2026, the Supreme Court handed down a 6-3 decision, striking down an executive order that attempted to end birthright citizenship in the United States. On paper, this reads as a straightforward victory for the rule of law. The Constitution held its ground, and the Chief Justice affirmed citizenship as a settled fundamental right. But accepting that surface-level narrative requires ignoring a rather glaring problem. We have to ask why a right debated, written, and ratified in 1868 required an 18-month legal spectacle to prove it still applied today. The 14th Amendment has endured massive systemic crises without buckling. It maintained its legal authority even through the severe civil rights violations of Japanese-American internment. It survived the pressures of 2 world wars and the entirety of the Cold War. In all that time, across multiple generations of restrictionist politics, no sitting president seriously proposed they could wipe away a constitutional provision with a pen stroke. The true danger of this event stems directly from the judiciary. By agreeing to hear the case, the Supreme Court took a brazen act of constitutional vandalism and dignified it as a legitimate legal question. Looking at the original text of the 14th Amendment, the law is completely unambiguous. It states clearly that all persons born in the United States and subject to its jurisdiction are citizens. To alter this constitutional baseline requires Article V's rigorous mechanism, 2/3 support in Congress, and ratification by 3/4 of states. Executive Order 14160 attempted to bypass this entirely, issuing a memo proposing a novel redefinition of jurisdiction. The order specifically targeted children born to undocumented parents or families visiting on temporary visas, unilaterally declaring they fell outside the country's jurisdiction. The lower district and appellate courts immediately identified this for what it was, a severe category error dressed up as legal scholarship. Every lower judge that examined the petition applied the established law efficiently, issuing brisk, unanimous dismissals across the board. When an executive branch attempts to rewrite a foundational guarantee while ignoring the amendment process, outright dismissal is the only proper judicial remedy. The petition did not earn a debate. Instead of letting dismissal stand, the Supreme Court granted certiorari before judgment. They even permitted the sitting president to attend oral arguments in person. By elevating a legally doomed petition to a headline event, the court transformed a frivolous theory into a highly dignified constitutional crisis. While that spectacle played out over 18 months, hundreds of thousands of children had their citizenship status treated as a live, open question. The majority did ultimately strike down the order, with conservative justices like Justice Barrett crossing over to protect the text. But the existence of a split decision at all reveals a deep institutional fracture. Justices Alito and Gorsuch managed to look at 130 years of settled precedent and somehow concluded the text was ambiguous. Justice Thomas offered a different route in his dissent, arguing the amendment was principally aimed at the formerly enslaved. That interpretation actively ignores the sweeping, generalized language the original drafters deliberately chose to establish a universal legal principle. 3 sitting justices examined a settled rule of law and voted to discard it. Their dissent demonstrates how easily motivated reasoning can masquerade as jurisprudence when an institution chooses to entertain a bad faith argument. The administration may have lost the legal verdict, but the ensuing theater successfully dragged the Overton window exactly where they wanted it. Lawmakers in Washington are now treating a constitutional floor as a simple statutory ceiling. A bill with dozens of co-sponsors is currently sitting in the House, aiming to strip birthright citizenship through standard legislation. The executive branch dismissed the court's ruling almost immediately, taking to social media to broadcast sarcastic congratulations to China on their restrictive citizenship laws. The Constitution survived this specific attack. The legal wall stood firm because just enough individuals eventually remembered their oath to uphold it. But the long-term outlook remains grim. Foundational rights are in extreme danger if the institutions meant to guard them require the Constitution to constantly prove its own existence in court.